Welcome back to Protecting Trade Secrets. This third lecture is the final segment of Module 1, where we establish the foundations of trade secret law. In the first and second lecture, we explored what trade secrets are, why they matter, and how companies choose between patent and trade secret protection. We introduced the UTSA and the DTSA as the two main statutory frameworks in the United States. Now, we're going to dig deeper into how those two systems actually work and how they differ in ways that matter for litigation strategy. Then we'll zoom out to the global landscape. Trade secrets don't stop at national borders. Companies operate internationally. Employees move across jurisdictions. Supply chains span continents, so we need to understand not just American law, but how major foreign jurisdictions, the European Union, China, Canada, Mexico, and Israel, approach trade secret protection. By the end of this lecture, you'll understand when to file in federal versus state court, what unique remedies the DTSA offers, and how to counsel clients with cross-border trade secret risks. Let's start with the domestic framework. The Uniform Trade Secrets Act, the UTSA, was promulgated in 1979 and amended in 1985. It's a model statute, meaning it was drafted by legal experts and offered to states for adoption. Today, 48 states, plus the District of Columbia, Puerto Rico, and the Virgin Islands, have adopted some version of it. Only New York, and to a lesser extent North Carolina, still rely primarily on common law, though even they incorporate UTSA-like principles through case law. The UTSA brought much-needed consistency to trade secret law. Before 1979, every state had its own rules, different definitions, different standards, different remedies. The UTSA harmonized that chaos by establishing the three-element test we discussed in the first lecture: information, economic value from secrecy, and reasonable efforts to maintain secrecy. But here's the catch. States didn't adopt the UTSA uniformly. Some states modified definitions. Some added carve-outs for specific industries. Some changed the statute of limitations, or the standard for awarding attorneys' fees. So even the Uniform Act isn't perfectly uniform. Then in 2016, Congress passed the Defend Trade Secrets Act, the DTSA. For the first time, trade secret misappropriation became a federal cause of action. Before 2016, if you wanted to sue for trade secret theft, you filed in state court under your state's version of the UTSA or under common law. Now you can file in federal court under federal law. Importantly, the DTSA does not preempt state law. You can sue under both. In fact, most plaintiffs today plead both DTSA and state UTSA claims in the same lawsuit. The two statutes are designed to work in parallel, but they're not identical, and those differences matter. Let's start with definitions. The DTSA defines a trade secret as all forms and types of financial, business, scientific, technical, economic, or engineering information that meets the secrecy and value requirements. The UTSA's definition is similar, but uses slightly different language. Information, including a formula, pattern, compilation, program, device, method, technique, process, financial data, or list of actual or potential customers or suppliers. The DTSA's language is broader. Courts have interpreted it to cover a wider range of information types. But in practice, the difference is marginal. Both statutes protect the same core categories: formulas, processes, customer lists, pricing strategies, source code, manufacturing techniques. The more significant difference is in the reasonable effort standard. The UTSA requires efforts that are reasonable under the circumstances to maintain secrecy. The DTSA requires reasonable measures without the under the circumstances qualifier. Does that matter? Not much. Courts applying the DTSA still consider context, the size of the company, the nature of the information, industry norms. But the textual difference could lead to slightly different analyses in edge cases. Another difference: the DTSA explicitly rejects the inevitable disclosure doctrine in certain contexts. The inevitable disclosure doctrine is the idea that if an employee knows trade secrets and takes a job with a competitor Disclosure is inevitable, so courts can enjoin the employee from working for the competitor even without proof of actual misappropriation. Some states embrace this doctrine, others reject it. The DTSA says you can't get an injunction solely to prevent future use based on inevitable disclosure unless there's evidence of actual or threatened misappropriation. You can't enjoin someone just because they might disclose secrets. You need proof they're likely to do so. That's a big deal for employee mobility. Under the DTSA, it's harder to use trade secret law to prevent employees from taking new jobs. The DTSA also offers two remedies that the UTSA doesn't: ex parte seizure and federal jurisdiction over nationwide service of process. Ex parte seizure is extraordinary. It allows a plaintiff to seize property, documents, computers, files, without notice to the defendant. Think about that. A federal marshal shows up at your office unannounced and seizes your servers. No hearing, no chance to object. It's one of the most aggressive remedies in civil litigation. Congress included ex parte seizure in the DTSA to address situations where trade secrets are at imminent risk of destruction or concealment. But the standard is extremely high. You must show that the defendant would destroy the evidence if given notice, that less drastic measures won't work, and that the harm to you outweighs the harm to the defendant. In practice, courts rarely grant ex parte seizure. It's been sought hundreds of times since 2016, but granted only a handful of times. Courts are cautious because the remedy is so invasive. But when it's granted, it's devastating for defendants. The other unique remedy is federal jurisdiction, with nationwide service of process. Under the DTSA, if you sue in federal court, you can serve defendants anywhere in the United States. You're not limited by state long-arm statutes. That matters when misappropriation involves multiple defendants in different states, or when the defendant is a fly-by-night operation that's hard to pin down geographically. These remedies make the DTSA attractive for plaintiffs. Federal courts, broader reach, more powerful tools. But there's a trade-off. Federal litigation is expensive, and federal judges are often less familiar with trade secret nuances than state judges who see these cases regularly. So when should you file under the DTSA in federal court, and when should you stick with state court under the UTSA? Here are 4 reasons to file in federal court. First, the misappropriation crosses state lines or involves defendants in multiple jurisdictions. Second, you need nationwide service of process to reach all defendants. Third, you think you might need ex parte seizure or other aggressive federal remedies. Fourth, you want the gravitas and procedural advantages of federal court, like more predictable discovery rules and potentially faster resolution. Here are 4 reasons to stick with state court. First, the dispute is localized. All parties are in one state, and the facts are confined to that state. Second, your state's UTSA has favorable precedent or remedies that the DTSA doesn't offer. Third, you want to avoid federal removal if the defendant might try to take the case to federal court anyway. Fourth, you're dealing with employment-related trade secrets, and your state has strong employee mobility protections that federal courts might not fully embrace. Many plaintiffs plead both. They file in federal court, asserting both DTSA and state UTSA claims. Courts apply both statutes side by side. The standards are similar enough that the analysis often overlaps. But having both claims preserves flexibility and maximizes remedies. Now let's turn to the international landscape. We'll start with the European Union. Before 2016, EU member states had wildly inconsistent trade secret laws. Germany had robust protections. The UK relied on breach of confidence doctrines. Other countries had minimal statutory frameworks. This patchwork made it hard for companies to protect secrets across borders within Europe. In 2016, the EU adopted the Trade Secrets Directive, Directive 2016/943. It required all member states to implement minimum standards for trade secret protection by June 2018. The directive harmonized definitions, clarified what constitutes unlawful acquisition, and established baseline remedies. The EU definition of trade secret closely mirrors the UTSA and DTSA. Information that is secret has commercial value because it's secret and is subject to reasonable steps to keep it secret. The directive lists specific acts that constitute unlawful acquisition, theft, bribery, breach of confidence, unauthorized access. It also explicitly permits reverse engineering and independent discovery, just like U.S. law. The directive emphasizes employee mobility. EU law strongly protects workers' rights to change jobs and use general skills and knowledge. Courts must balance employers' interests in protecting secrets against employees' freedom of movement. This is more protective of employees than many U.S. jurisdictions. One unique feature: the directive includes explicit protections for whistleblowers. If someone discloses a trade secret to report illegal activity or to protect the public interest, that disclosure is lawful. This is similar to protections in the DTSA, but the EU framework is more developed. Enforcement varies across member states. The directive sets minimums, but countries implement it through national laws. Germany's implementation is strong. France has detailed procedural rules. Smaller countries may have less developed enforcement infrastructure. Companies operating in Europe need to understand not just the directive, but how each country has implemented it. China's trade secret landscape has transformed dramatically over the past decade. Historically, China was seen as a high-risk environment: weak enforcement, difficulty gathering evidence, limited remedies. But reforms to the anti-unfair competition law, particularly amendments in 2017, 2018, and 2019, have strengthened protection significantly. Article 9 of the anti-unfair competition law now defines trade secrets and prohibits their unlawful acquisition, use, and disclosure. The definition aligns with the UTSA and DTSA, information not known to the public with commercial value and subject to confidentiality measures. Recent amendments shifted the burden of proof in key ways. If a plaintiff shows that it took reasonable confidentiality measures and that the defendant had access to the information, the burden shifts to the defendant to prove they didn't misappropriate. That's a huge advantage for plaintiffs, especially in cases where direct evidence is hard to obtain. Chinese courts have also increased damages. In high-profile cases, courts have awarded hundreds of millions of renminbi, far more than in the past. Criminal enforcement has ramped up too. Prosecutors now pursue trade secret theft aggressively, especially in cases involving technology or national security. But challenges remain. Discovery is limited compared to U.S. litigation. Evidence preservation can be difficult. Enforcement varies by region. Courts in Beijing, Shanghai, and Shenzhen are more sophisticated than courts in smaller cities. Foreign companies operating in China often implement layered strategies: keep the most sensitive processes outside China, use robust NDAs and employment agreements, segment information so no single entity has complete access, and monitor departing employees closely. Canada doesn't have a single national trade secret statute. Instead, it relies on provincial laws and common law principles of breach of confidence. The core elements are similar: secret information, communicated in confidence, and misused to the detriment of the owner. Canadian courts often cite both English and American precedent. Enforcement is generally reliable, though damages tend to be lower than in the United States. Mexico's federal law for the protection of industrial property governs trade secrets. Recent reforms, particularly under the USMCA, which is the United States, Mexico, and Canada agreement that replaced the North American Free Trade Agreement, have aligned Mexican law more closely with U.S. standards. The law defines trade secrets using the familiar three-element test and provides injunctions and damages for misappropriation. Enforcement has improved, but procedural challenges remain, litigation can be slow, and gathering evidence is harder than in the United States. Israel's trade secret framework comes from the Commercial Torts Law of 1999 and case law. Courts emphasize the balance between protecting secrets and promoting employee mobility. Israeli law is sophisticated and generally favorable to rights holders, especially in technology sectors where Israel has deep expertise. Enforcement is proactive, and courts understand the dynamics of innovation and competition. Let's recap. The UTSA and DTSA form a parallel system in the United States. They're similar in structure, but differ in key details: definitions, remedies, and standards for injunctions. Plaintiffs often plead both, and courts apply them side by side. Internationally, the EU Trade Secrets Directive has harmonized protections across Europe, though implementation varies. China has strengthened enforcement dramatically, though challenges remain. Canada, Mexico, and Israel each have frameworks that align broadly with U.S. principles, but reflect local legal cultures and procedural norms. For companies operating globally, the lesson is clear. You need a multi-jurisdictional strategy. Understand the local law, tailor your protections to each jurisdiction, use NDAS that comply with local standards. Train employees on confidentiality obligations that reflect the legal environment they're working in. And when misappropriation happens, move quickly, because the procedural tools and timelines vary widely from country to country. In the next lecture, we'll shift from theory to application. We'll break down the three-element test element by element. We'll look at cases where plaintiffs won and cases where they lost, because they couldn't prove information, economic value, or reasonable efforts. We'll start building your toolkit for advising clients on what qualifies as a trade secret and what doesn't. Thanks for listening. I'll see you in the next lecture.